5, 4, 3, 2, 1. In view of the aforesaid discussion, we sum up and lay down the following principles by which the High Court would be guided in giving adequate treatment to the settlement between the parties and exercising its power under Section 482 of the Code while accepting the settlement and quashing the proceedings or refusing to accept the settlement with direction to continue with the criminal proceedings. Power conferred under Section 482 of the Code is to be distinguished from the power which lies in the court to compound the offences under Section 320 of the Code. No doubt, under Section 482 of the Code, the High Court has inherent power to quash the criminal proceedings even in those cases which are not compoundable, where the parties have settled the matter between themselves. However, this power is to be exercised sparingly and with caution. When the parties have reached the settlement and on that basis petition for quashing the criminal proceedings is filed, the guiding factor in such cases would be to secure ends of justice or to prevent abuse of the process of any court. While exercising the power of the High Court is to form an opinion on either of the aforesaid two objectives. Such a power is not to be exercised in those prosecutions which involve heinous and serious offences of mental depravity or offences like murder, rape, dacoity, etc. Such offences are not private in nature and have a serious impact on society. Similarly, for the offences alleged to have been committed under special statute like the Prevention of Corruption Act or the offences committed by public servants while working in that capacity or not to be quashed merely on the basis of compromise between the victim and the offender. On the other hand, those criminal cases having overwhelming and predominantly civil character, particularly those arising out of commercial transactions or arising out of matrimonial relationship or family disputes, should be quashed when the parties have resolved their entire disputes among themselves. While exercising its powers, the High Court is to examine as to whether the possibility of conviction is remote and bleak, and continuation of criminal cases would put the accused to grade CRMP number 2650 of 2020, oppression and prejudice and extreme injustice would be caused to him by not quashing the criminal cases. Offences under Section 307 IPC would fall in the category of heinous and serious offences and therefore are to be generally treated as crime against the society and not against the individual alone. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.